Hello, everyone, and welcome to today's webinar entitled The Madrid Protocol, Issues and Challenges in Cambodia, Indonesia, Laos, Thailand, and Vietnam, presented by Tillicki and Gibbons. I am Michelle Ray Jones, and I will be your moderator today. I am located in Tillicki and Gibbons' Bangkok office, but before moving to Thailand 8 years ago, I was a trademark prosecutor and litigator in New York. So I hope that my experience in both North America and Southeast Asia will help to enliven today's discussion. I will be joined by my colleagues Sombun Ertaratsarun, Sokmin Chia, Rina Sinaga, and Mailing Nguyen. This webinar will start with a short introduction, which will be followed by presentations from my colleagues. And at the end of the webinar, we will have a Q&A session. We very much encourage questions from our audience. So if you have questions, please feel free to click on the box that says Ask a Question. When you type your question, it would be very helpful if you could indicate the country that your question pertains to, or if you'd like all of our speakers to answer your question, please let us know. Just a note that we will hold any questions to be answered after all of our presenters have spoken. So we're not ignoring you. We'll see your questions and we welcome them, but we're just going to wait until the end. We note that this webinar will be recorded, and if you'd like to obtain a copy, you can contact us or you can find it on Tillicki and Gibbons' YouTube channel. And finally, I'd like to note that this session will present a high-level tips for trademark applicants and their counsel. So we'll not be going through the basics of Madrid Protocol application. We'll assume that the audience has an understanding of the Madrid system. However, if you wish to learn about the basics of Madrid, please feel free to reach out to any of the speakers or myself, and we would be happy to assist you. Okay, great. So before we begin our discussions of the individual countries, I'd like to provide some context to set the stage. As many of you know, the original Madrid Agreement was established all the way back in 1891, and the Madrid Protocol, which has maintained the original intentions of the agreement, but ironed out some of the discrepancies and the deficiencies of the original agreement, was adopted in 1989. And since its adoption, countries around the world have steadily been joining. And out of the countries represented in today's webinar, Vietnam has been a member for the longest number of years, having joined in 2006. And 9 years later, in 2015, Cambodia joined. And this was followed by Laos, which joined in 2016. Most recently, in 2017, Indonesia and Thailand became members. So it can be said that Vietnam is the elder statesman, while Indonesia and Thailand are the newcomers. So when we think about issues facing Madrid applicants, there are generally two kinds. That is, issues relating to the handling of the basic application before WIPO, and issues relating to the handling of the extensions of protection to each designated country. So issues faced before WIPO can include notifications regarding the descriptions of goods and services, sometimes, although rarely those are issued by WIPO, and issues with payments and deficiencies that also sometimes come up. A recent issue that IP practitioners will know about is WIPO's new requirement that every Madrid application must include the email address of the applicant. And the email address must not contain the same domain name as the law firm. So this means we all have to inform our clients about this new issue and ask them for an email address. So, our practice regarding Madrid applications continues to change, and I think this will highlight some of those things that we all need to stay on top of. Talking about individual countries, the issues that can be faced are refusals on substantive grounds, requirements to amend goods and services to comply with local practice, and many other issues. We'll definitely talk today about some of the main issues that come up in each of our countries. In Thailand, we're notorious for having lots of refusals on the descriptions of goods and services and on other issues. So we'll delve into that and how those can be avoided. Before joining Madrid, of course, each country has to agree to follow the protocol and the regulations. So that provides some consistency. And of course, new members receive extensive assistance and training from WIPO. So many of the processes are similar among member states. However, this does not mean that each country handles Madrid applications in the same way, and countries are allowed a fair amount of autonomy in their procedures. Some of these differences can be researched and answers can be found on the Madrid website. For example, the period of time during which a country agrees to issue a refusal notice, that's information that of course is available on the Madrid website. But there are other differences that can be difficult to learn about prior to filing. So in this webinar, we'll delve into these jurisdictional issues and discuss whether they can be avoided, whether there are any workarounds, or whether the applicant should simply choose the national route in certain circumstances. So with that as an introduction, I would like to introduce our first speaker. So representing Laos and Thailand is our first speaker, who is Sombun Ertaratsarun, a partner in the Tilaki & Gibbons Intellectual Property Group. Kun Sombun is well known for his vast knowledge of IP protection, and he has presented on the topic to numerous organizations based in ASEAN. He is an expert in formulating strategies for the successful management of worldwide trademark portfolios, as well as employing customized techniques for protecting and enforcing clients' trademark rights on a global basis. Sombun is consistently recognized as one of the region's leading intellectual property practitioners by industry publications such as Managing Intellectual Property, World Trademark Review, and the Legal 500 Asia Pacific. So welcome, Sombun, and away you go.
Well, thank you very much, Michelle. Would you mind helping to confirm if you hear me okay, and then my presentation is on your screen right now?
Yes, I hear you very well, and your presentation is visible.
Okay, perfect. Okay, so good morning, good afternoon, or if any of you are in Southeast Asia, good evenings to you. Thank you very much for joining in this webinar run by Tilaki & Gibbons, and we are honored to have you here. And we hope that the presentations that is going to be presented by me as well as my colleagues across offices in Southeast Asia will be able to provide you some insight into how Madrid applications are being handled by each trademark office in Southeast Asia. So let me begin with Laos. I have a privilege to cover two countries, so I'm going to spend the next 20 minutes with you guys, so please bear with me on this. So for Laos, these are some of the high points that we would like to highlight to you guys. First, there will be a separate trademark examiner teams between the national applications and the IR applications. So what it means is for national applications, it will be examined by the usual non-English trademark examiners, but the application filed through IR are going to be examined by as separate groups, which are full of people who are well conversant in English. So on that note, they will be able to pick up more of the tricks that you are using around the brand. For example, if you are trying to work around the non-distinctness issues by doing some misspelling brand, that is going to be picked up by the trademark examiners in these particular groups. So it could suggest a little bit more difficulties in having IR registered in Laos, but it's not the whole story, because we do see, based on our observations, that there are higher rates of refusal as compared to national application, but the examiners are more receptive to our arguments and foreign evidence, because let's face it, Laos has joined Madrid in 2016, but only that in 2020 that we started to see more provisional refusal coming out. And obviously, the Laos trademark examiners are pretty much receptive to any type of documents or evidence that you can show. Say, for example, if you are trying to fight on non-distinctiveness issue, and then you already have obtained a registration for the same mouthful more than 20 countries, for example, it's very likely that you are going to be able to get it done in Laos as well. On similarities issue, you probably might want to research if there are any coexistence between the marks elsewhere, and if that is the case, or even if you have a coexistent agreement or even letter consent, those kind of evidence will be able to get yourself overcome the provisional refusals in Laos. And based on our own statistic at our firm, we have been receiving around 50 provisional refusals in Laos. And out of those applications that we already started to receive the result, we got 100% winning on the refusal, which means that they are very, very much receptive to any arguments that you are going to make. Next, that after a provisional refusal is taken care of, and then there will be a statement of grant, which I'm going to show you in the next slide. So this is going to be a statement of grant following a provisional refusal. So this is a type of documents that you will be able to download from WIPO website. But as you can see, there are only a few details to that particular registration. So the list of goods are not right there. And there are some reference to rules of the common regulations of Madrid, which obviously is not going to be known by police in Laos, by authority customs in Laos. So if you envision possibilities of enforcing your trademark rights in Laos, we are going to strongly recommend that you get a local certificate, which in the case of a provisional refusal, you will be able to get it from your lawyers as well. The local certificate will be issued to the appointed law firms. So please make sure to check with them. And be careful when designating partial list of goods, because there are times we have to admit another fact, which is the Laos JP are relatively new to the system, and they don't have a full scale of manpower. So some of them might still get confusing as to what has been designated into Laos. So they often would take the whole thing. So even though you have 10 classes filed based on your basic mark, but you probably might want to designate only 3 classes in Laos. But there are chances that provisional refusal might be issued against all of your classes. So we can help you to identify that with the Laos JP and get things done and figure out a new provisional refusal for you. So this can be done, but please make sure that you check provisional refusal carefully. Okay. Based on the number of application files in Laos, that's probably the most high point that we would like to raise. Then I'm going to move to Thailand so that we will be able to spend more time on Thailand, simply because, as Michelle has said upfront, Thailand has been notorious of issuing a lot of provisional refusal, and that's the fact. So let's see what are the high points that you should be aware of. So first, one good thing about IR is that if you file through IR designating Thailand, you are going to get 90 days deadline to respond to office actions or appeal against that refusal, whereas for a national application, you get 60 days. And a notarized power attorney is required to appoint a local representative, even though a late submission is available, but it's not always the case. So please make sure that you are going to get back to your lawyers in time, at least just a week before the deadline. That would be advisable, because there could be times where a late submission will not be acceptable. For example, in the case of oppositions, a late submission of the power attorney will not be allowed in the case of opposition. Another key point for II in Thailand is that a lead time for issuing a provisional refusal will be close to 18 months, because that's the deadline for the trademark office, right? as compared to 12 months of national application. And the rationale here is that when you designate Thailand through your IR, then all the applicant name, address, as well as the list of goods and services will have to be translated into Thai for examination purposes. And then the Thai trademark examiner are going to examine based on the Thai translation and then issue a refusal or issue a statement of grant. So because there is one step in addition to the national application that's contributed to the delay to almost 18 months. So if you want to get things done or quicker in Thailand, IR might not be your answer. And that's will lead to my another point. Only 2 months ago, Thailand Department of Intellectual Property has issued fast-track examination and also fast-track renewals. So let me touch on the fast-track renewal first. So fast-track renewals means when you file the renewal application, and if your condition met, for example, you have less than 30 lists of goods, and then you have all the applicant name and address correct, so there is no amendment. So in that case, you can get renewal done within 60 minutes. So that's the promise from the Department of Intellectual Property in the case of renewal. But in the case of trademark prosecution, a new trademark prosecution, if your conditions are met, which means you have less than 10 items of goods in each class, and then your descriptions are taken from the Department of Intellectual Property's manual, then you will be able to get the first office actions or a notice of publication within 6 months, as opposed to, again, the 12 month. But these fast track routes are only available for national applications only. So if you file an applications and designating Thailand, the first thing that the trademark examiner are going to look at is formalities examinations. So the list of goods and services, Thailand again has been notorious for being very picky about the list of goods and services. So if you are going to designate things like clothing, footwear, headgear, cosmetics, you can be sure that these terms are going to be rejected. And if you want to check as to what are the acceptable type of goods, please look at the website here. This is the link where you can put in, and one in your browser, it's going to show you something like this. So you can simply put in the search space right here. You can put cosmetic, for example. You can put pharmaceutical preparations right here, and it will show you as to what are the acceptable terms that has comprising of those goods. Obviously, you don't have to stick to this manuals, because this manual we're talking about around 10,000 items. But in the real world, there are much more than that. So if you want to use some other terms besides things that are listed in this manuals, that's your choice. But it would also mean that you will not be able to benefit from the fast track examination that I spoken before. Okay, and then again, I would like to reiterate that because of the dual language examinations, this will lead to multiple office action, because for national application, what they care are only to check on the Thai description of goods, right? But for IR, so once they translated your applications into Thai and then examine it and probably issue provisional refusal, we as your local practitioners would then have to find an amendment. In our amendment, we would have to include both Thai and English equivalents to that. So as you can imagine, now the examiners would have to look into both the Thai and English description if they match. So that always lead to multiple office actions because of this. Okay. But that has been what was the situation in the past. But we have some good news for you as a brand owners as well. In April, the Department of Intellectual Properties has put on hearings of a new examination guideline. And in that examination guideline, there are a lot of areas where they become more lenient in examining trademark applications. And these are some of the highlights that I would like to flag these to you, especially on the distinctiveness of mark examination. And this particular guideline is being reviewed after the hearings in April. So we anticipate that in June, the new guideline will become applicable, and it's going to be shaping all the future examination of trademarks in Thailand, either through Madrid or national application. So the first thing, I understand that there are some Chinese participant right here too. So you would understand what I mean. In the past, for Chinese characters, as all of you know, each Chinese character has its own meaning. But when you combine it to make a coin word, it doesn't have any meaning in most cases. But in the past 20 years, the Thai trademark examiners, even though you said a combination of these two Chinese characters would not mean anything, but they would look at the individual's meaning of each characters, and if the meaning of each individual's characters could form a certain meaning, then they are going to reject that based on the descriptiveness issue. But that is not going to be the case anymore, because in the new guideline, they already be more flexible in accepting that if a combination of two or more Chinese characters will form a new word without any meaning, then it's a coin word, it's an invented word, so it will be sufficiently distinctive. Three-letter mark, this also has been one of the most problematic fields and areas in Thailand, because a lot of you would not believe that a trademark like BMW's, MTV, HTC, DKNY, for example, are all rejected in Thailand before, because in the eyes of the Thai trademark examiners as well as the Board of Trademark, a letter mark would be registrable only if you stylize it into a fanciful font. So you have to stylize the fonts. If you try to file an application for BMWs, but you put it as a Times New Roman block letters or word mark, that is going to be rejected. But again, good news is after June, probably they are going to be acceptable to any three-letter mark. So sorry about a two-letter mark, for example, O2 or something like that would still be rejected. But a three-letter mark would now be acceptable. But you need to be aware that they are going to accept it if the order of the letters are not in alphabetical order. So things like A, B, C will still be rejected, but things like HTC, BMWs, NTT, so on and so forth will now be acceptable. Next, the disclaimer. In Thailand, I think that this also be aligned with the US as well. If the trademark examiners views that in a trademark that has been filed, there are two parts: the parts where there are distinctive and the part where it's not distinctive. It's the job of the examiners to determine as to whether or not the distinctive part is the material part or essential part of the mark. If it's not, then the whole mark is going to be rejected. But if the distinctive mark outweighs is the material part of the mark, then it's going to be acceptable under a disclaimer of the non-distinctiveness part. But that has been, as you can imagine, pretty much discretionary and also subjective. So they try to make it more objective by stating that the way that they are going to determine if the distinctive part is the material part or not, they're looking at the size of the distinctive part as compared to the whole or the entire of the mark. If the distinctive part forms 60% or about 60% of the mark, then it's going to be considered as being material part and it's going to be acceptable. But if the distinctive part is less than 60%, then it's very likely that they are going to consider that a non-distinctive mark and then reject. Similar to Laos, you need to be very careful when the designating partial list of goods because, again, like Laos, the Thai trademark examiners are still working on to understand the system clearly. So sometimes they do take a wrong list of goods. They take the whole thing as opposed to the partial list of goods that has been specifically designated for Thailand. And one last thing, the local certificate will be issued in addition to the statement of grant. And again, similar to Laos, this is going to be sent to your appointed local lawyers in Thailand. And that is going to be very, very useful in the case of enforcement. So that's all the high point that I would like to raise. But if you have any questions, feel free to put in the chat box or the place where Michelle has highlighted, and we will get back to that. And after my colleague have finished their own presentations. But for now, I would like to get it back to Michelle. Thank you very much.
Thank you. Very helpful. I'm hoping that some of these issues will get straightened out in Thailand after we've been a member of Madrid for a little bit. Hopefully, it'll resolve some of these issues that we have. But right now, we still have these issues, so good to highlight them. Okay, wonderful. All right, so our next presenter is Sokmin Chia. She's an advisor in Tilaki & Gibbons Phnom Penh office. Sokmin assists her clients with a range of intellectual property issues, including trademark and patent registration, developing anti-counterfeiting strategies, conducting enforcement actions, negotiating with government authorities, and navigating the regulatory landscape in pharmaceuticals, food, cosmetics, and agrochemicals, among other industries. She is an active participant in national and international intellectual property organizations, and she currently serves as Vice President of the Cambodia chapter of the Asian Patent Attorneys Association. So welcome, Sokmin. All yours.
Yeah, thank you very much, Michelle, for your introductions again. So today I would like to discuss about the issue and challenging in Cambodia regarding to the Madrid Protocol that most of the IP owner might face during obtaining the registration of their international trademark application. Yes, so first of all, I just want to inform you that currently the DIPR have divided the examiner into two groups. So one group will be responsible for national trademark application, and the other group will be responsible for the international trademark registration. Regarding to the timelines to issue the first notice of refusals for international trademark application would take up to 18 months. Compare it to the national trademark application would take only 5 to 7 months from the filing date. The other points that I would like to highlight is about the goods and services. So before the examiner conducts the substantive examination, the examiner will check whether the goods and services are compliant with the Cambodian Trademark Office. So it is important to note that Cambodia does not accept class heading for the application. So in the event that your application contains the niche classification, make sure that you have to provide the detail of list of goods and services of your marks. So I would like to inform you that if your international trademark application designated into Cambodia and the goods and services are in class heading, the DIPO will issue a notice of provisional refusal by requesting the applicants to provide the detail of list of goods and services. So in that stage, the applicant can provide the detail of list of goods and services as broader as possible, because in Cambodia, there is no limitation regarding to the number of goods and services. And the cost will not be affected by the number of items of list of goods and services being applied for as well. Moreover, broader goods and services will have no impact when the applicant file the declaration of use during the required period of 5th and 6th year from the registration date in Cambodia. Regarding to the classification, I would like to inform you that Cambodian apply the current list classification version, so it is possible to apply all the version in Cambodia. So in the event that your international application is rejected by the DIPO due to the class heading, there are two options that the applicant can overcome these refusals. The first option is that the applicant can file a request for amendment of list of goods and services with the IB office. And the second option is that the applicant can file a request for amendment of list of goods and services directly to the DIPO by paying the official fees to the office. So in order to overcome the refusals, the applicant have to appoint a local representative to respond to the refusal and handling the case. So in the event that the client want to choose the first option to respond to the refusal, the applicant have to file the request for amendment in the form of MM6 to the IB office, and then you have to file a written response to the DIPO providing with the requested as filed with the IB office and submit it to the DIPO. Similarly, if the client choose the second option, the applicant have to request the amendment of list of goods and services with the DIPO by paying the official fee, and then they have to submit their written response along with the requested as filed to the DIPO in order to overcome these refusals. Based on our practice, it is recommended that the applicant should choose the second option. It means that they should file the request for amendment of list of goods directly with the DIPO. Why? Because the process of updating and recording the detail of list of goods and services will be faster than filing the request for amendment of list of goods and services with the IB office. So the second option is the best for the clients. And the other issue that I want to highlight is about the delay in the recorder of change. It is possible that international trademark owner can file a request for change of name or address or assignment or partial assignment with the IB office. However, if the change does not reflected recorded at the DIPO's database, it is important for the applicants to have a local attorney to follow up with the DIPO to make sure that the change are reflected in the DIPO database. The effect is that if the change of that does not recorded correctly with the DIPOs, the effect is that the statement of grant of protection or the office of action may be issued in the name of the old owners. Yes, can you click it next, Michelle? Yes, thank you, Michelle. So the other point is about the disclaimer practice in Cambodia. Some of you may know that Cambodian adopt the disclaimer practice. So it is common that the disclaimer will be provided, will be requested by the examiners to the applicants to disclaim the non-distinctive terms. So the issues that I want to raise here is about the one or two normal letter or number that the Cambodian DIPO consider that these are non-distinctive. So concerning to this point, it is important to note that if your mark contains a one letter or number or two letter or two number, or the mark is a combination of one letter, two letter or number together with the other element of the mark, it is possible that the DIPO will issue a notice of provisional refusal by asking the applicants to disclaim such term. So if the client agree with the disclaimer, the DIPO will grant the protections to that mark. However, if the client does not agree with the disclaimer, the client can also file an argument against the refusal as well. Based on our practice, I can say that the DIPO will not agree with that argument. So the DIPO will issue a second notice of provisional refusal by asking the applicant to disclaim such terms again. So once the DIPO issue this second notice of provisional refusal, the client or the applicant can also have another chance to disclaim such term during issuing the second notice of provisional refusal. So this is common to know that this disclaimer is mandatory to agree with the DIPO suggestion, and this is the first option that you can have the trademark to be registered in Cambodia. Another point that I want to highlight is about the declaration of use and non-use. According to Cambodian trademark law, the IP owner have to file a request of declaration of use and non-use with the DIPO during the 5th and 6th year from the registration date or from the renewal date. Similarly, for the international trademark registration, the IP owner have also filed a declaration of use and non-use with the DIPO as well. So it is important to note that the holder of the international trademark registration must file a declaration of use and non-use during the required period. And if you cannot meet the requirement, your international trademark registration will be no longer protected in Cambodia. The other ones that I want to discuss as well is about the certificate of trademark registration. As for national trademark application, when the trademark is mature for registration, the DIPO will issue a physical certificate to the applicant. However, for international trademark application, the DIPO will only issue a statement of grant of protections to the applicant. So in the events that the applicants want to have the physical certificate of registration, the applicant can also file a request for duplicate of certificate of registration with the DIPO by paying the official fee for that. So I can say that the certificate of registration is very important if the trademark owner want to take actions against the infringer, wants to do the enforcement case in Cambodia, because when you file a complaint to the authority will require you to show the physical certificate of trademark registration to prove that you are the legitimate owner of that trademark in Cambodia. So it is recommended that the applicant should have the physical trademark registration in hand before taking any actions against the other party. And it is also for you to show that proof to the authority without delay. Yeah, so this is all about my presentation. So if you have any question, please feel free to ask us in the chat box here. So we are happy to answer to your question, or you can email us if you have any question about this. Yes, thank you, Michelle.
Thank you so much, Sophie. It's super interesting to see the differences between Cambodia and Thailand and Laos, and very, very interesting. Thank you very much. Okay. All right, so our next presenter is from our Indonesia office. Rina Sinaga is a registered intellectual property consultant in Tillich & Gibbons Jakarta office. She assists domestic and international clients on a range of trademark matters, including searches, registration, prosecution, recordal of changes of address and assignments, and oppositions, cancellations, etc. She's also involved in advisory opinions, negotiations, trademark protection strategies, and the commercialization of clients' IP assets through agreements and franchising. Rina is a member of the Indonesian Bar Association, and she is a registered IP consultant. So Rina will help us today learn about Indonesia. So off to you, Rina.
Good night. I will share about the challenges and issues related to implementation of Madrid Protocol in Indonesia. The highlight of the issue we will share here is based on a question frequently asked by client. Okay, I will start with a short comparison between national registration and international registration, or IR. Overall, the procedure of registration stipulated for national registration will also apply for IR, including the time frame for filing a response to professional refusal and time frame for filing an appeal. However, we found there are some differences among others, as you can see on this slide. For national registration, formality examination is still required. A response to office action is usually completed in 9 to 12 months, but by the law, actually the time frame for registration, national registration is faster, but in practice, the time frame for national registration is much longer than IR. The specification of kinds of goods or services must be chosen from the DGIP e-filing system, and for treatment for enforcement is the same between the national registration and IR. For international registration, the DIP will not do formality examination, so no formality is necessary, and the response to office action is much faster than IR, than national registration. And the specification of kinds of goods or services refers to the basic registration. Here is the summary of the procedure of IR in Indonesia. After receiving an IR from International Bureau or IB, the DGIP will publish the application for 2 months. Once the publication period ends, the DGIP will substantively examine the IR, and if there is no any similar prior mark, DGIP will then issue a certificate and or grant of notification for IR. So far, we found that DGIP issue provisional refusal based on these 3 grounds. The first is office action due to prior mark. The second is office action because of lack of distinctiveness or the mark related to the goods or services applied for. And the third is office action because of bad faith, but this kind of rejection is very rare and usually occurs to logo mark. When a notice provisional refusal is issued by DGIP, the applicant will receive the cover of the notification with the IB logo and the notification itself with the DGIP logo. You can see in this slide the appearance of the cover and the notification. In the cover of the notification, we will find the information relating to the date of the notification sent by IB to the applicant. So, as shown in the yellow highlighted here, the deadline to file a response will be calculated from this date. And then the requirement for filing a response to office action is described in the point number 7 in the notification is shown here. If the notice of provisional refusal only affect some kinds of goods or services, the applicant can submit a request of limitation or voluntary deletion of the non-conflicting goods or services directly to IB. But make sure you also inform the request of the limitation to the email mentioned in the notification. Here is the most common issue we deal so far. The first is when we check the DGIP website, the DGIP website never almost never show the image of the mark, and we also found that the Indonesian translation of the goods or services made by DGIP is sometimes not clear, so this can be a problem in the case for further comparison with submitting responses. The other issue we deal is we found that DGIP sometimes forward the examination result only to the applicant. So this can be a problem too in case the response is rejected, because we need to, or your local representative need to determine the appeal deadline. The other issue is the error made in the rejection statement. If it often happens to multiple application, that DGIP doesn't issue a provisional refusal mentioning that the refusal affects to all of the classes, but actually the cited mark only, for example, only in one class. But in this case, although the provisional refusal only cite one class, you or the applicant still need to submit a response to the DGIP. So the rest of the classes in the IR will be can be protected. So we would suggest you as the applicant to follow these following steps in case you wish to file a response to office action. The first, please provide the image along with the origins of kinds of goods or services in your IR to your local representative for further comparison, and also provide the result of the examination of the response to your local attorney. And then we also suggest to submit a response to secure the non-overlapping class or goods in case the refusal only affect some of classes or some of goods in your IR. I hope this explanation helpful. If you have any query, please contact us or we can discuss further in this forum. Thank you.
Thank you so much, Rina. Super interesting again to have your perspective, to hear about some of the issues that might be faced by trademark applicants in Indonesia. So I'm sure we can learn something from your presentation. Last but not least, we have a representative from our Vietnam office. Lynn Nguyen is a partner and heads the Tillich & Gibbons trademark team in Vietnam. Lynn brings to the firm a comprehensive understanding of Vietnamese IP law, which is the product of more than a decade of experience as a lawyer advising owners of world-famous brands on protecting their rights in Vietnam. She is recognized as a leading trademark attorney by the WTR 1000, and she has crafted persuasive arguments to win appeals and oppositions for foreign trademark holders in the fashion and consumer goods industries. So welcome, Lynn, and the stage is yours.
Okay. So good evening and good morning, everyone. Thanks, Michelle, very much for the kind introduction. I am glad to join our today's presentation on issues and challenges for IR designating Vietnam. As Vietnam has joined the Madrid Protocol for quite some time, its examination for IR are rather smooth and does not pose a lot of challenges for the brand owners. Nevertheless, similar to other countries, national registration and IR are examined by different divisions of the Vietnam IPO. The national registration are examined by the trademark division, while the IR are examined by GI and IR divisions. And because of that, there are still some issues and differences in practice between national registration and IR that trademark owners may need to take into account. First of all, different to Thailand, Vietnam IPO does not require to translate the list of goods and services into Vietnamese. The IPO also does not examine formality of an IR. In principle, the IPO can do the examination as to formality for an IR, and in practice, recently there have been some cases where the IPO requires the applicant to clarify some goods and services. Nevertheless, it is very rare. As such, generally, once the IR are accepted in terms of formality by the WIPO, the IR will go directly into the substantive examination by the Vietnam IPO. Second, the time frame for substantive examination of IR in Vietnam is 12 months. For national registration, the examination period is 9 months under the law. However, in practice, it is often prolonged to 18 to 20 months. However, it is expected that the Vietnam IPO will try to accelerate the examination for national registration to meet with the time frame under the law, which is 9 months. If so, the time frame for national registration will be shorter than for IRs. For IR, the IPO cannot prolong the substantive examination. It should complete the substantive examination strictly within 12 months. If no provisional refusal is issued within that time frame, such IR will be automatically protected. In the past, there are several cases where the IPO issued provisional refusal for IRs after the 12-month period. In these cases, the trademark owner only needs to file a simple response indicating that the refusal was issued after the prescribed time frame and does not need to respond on the merits of the refusal. Due to the strict timeline for examination, Vietnam IPO has to use all of its resources to fulfill the examination within the 12-month time frame. As a substantive examination, IR could also face a rejection for the same reasons as national registration, such as being descriptive, misleading, or due to a citation. However, in some situations, national registration and IR could be handled differently. One of the situations is for complex marks. For example, a mark includes both word element and design element, which are equally strong elements of the mark. If the IPO filed a citation for the design element only, the IPO may refuse the IR entirely. However, if such mark is filed as national registration, the IPO would refuse the mark partially for the design element only. If the applicant agrees with such partial refusal and deletes the design element, the word element of the mark can still be protected. Regarding to the certification, if the IPO found some of the goods or services are problematic, such goods and services would be refused, and the remaining goods services can be automatically protected if the mark is filed via the Madrid Protocol. However, if the mark is filed as national registration, even if the applicant agrees with the refusal, the applicant needs to file a response stating their agreement to the refusal. Or if the applicant does not agree with the refusal, the applicant can divide the application into two parts, one for the refused goods and services, and the other for the non-refused ones, and then deal with each divided application separately. For IR, it is not possible to divide the IR. Also, if the applied mark is a 3D mark incorporating the shape of the product or shape of the container, national registration and IR are also treated differently. Generally, conventional shape of products and shape of container are not registrable in Vietnam, even if such shapes are combined with other distinctive elements, such as a house mark or a logo of the applicant. The mark will still be refused entirely if such mark filed as an IR. However, if such mark is filed as a national registration, it will be protected as a whole, and the IPO will impose a disclaimer on the 3D shape. Even though the 3D shape, which is a conventional shape of products, is not registered, the registration of the mark in its entirety still provides some protection and may facilitate the enforcement actions. So for 3D marks, it is highly recommended to file the marks as national registration. After the substantive examination, if the mark is refused and the applicant wishes to challenge the refusal, then we need to file a response either with the trademark division in case of a national registration or with the GI and IR division if the mark is an IR. This is where the significant challenges for IR occur. As mentioned previously, due to the strict timeline for examination for IR, the GI and IR division has to use all of its resources to fulfill the commitment of completing the examination within the 12-month time frame. Because of that, they do not have resources for other tasks, including for handling response to refusal. As such, it often takes very long time for responses to provisional refusal to be handled, often take around 4 to 5 years. For the information, almost all of the responses to provisional refusal filed with the GI and IR division since 2018 are still not yet settled. Meanwhile, responses to refusal for national registration are often settled within 12 months. The practice of disclaimer for IR is also different. Specifically, Vietnam IPO will not indicate any disclaimer for IR, but this does not mean that IR will enjoy protection without disclaimer. The IPO will still disclaim some element of an IR if its five sub-elements are indistinctive. However, the IPO will only keep such disclaimer in its internal database, which is not accessible to the public. To find out of the disclaimer, the applicant will need to check the status of the IR with the IPO. And last but not least, when it comes to enforcement, the enforcement authorities in Vietnam often require the trademark owner to present a certificate of registration. As the Vietnam IPO does not automatically issue such certificates for IR, in case of enforcement, the trademark owner will need to obtain a certification of validity from the Vietnam IPO. Unfortunately, due to the limited human resources of the IPO, the process to obtain such certification may take several months, sometimes half a year. So, all in all, IR has some advantages and disadvantages comparing to national registration. I hope that my presentation can help you to choose a suitable route for yours and your client's trademark. Thank you everyone for listening, and please feel free to let us know if you have any questions.
I will start by addressing the questions that are explicitly for Cambodia. So Sokmin, you're going to be on first. Okay. So the first question we received is a declaration of use and a declaration of non-use. Do they have the same effect to maintain the registration?
Yeah, thank you for the question. This question is very good and very important for all the IP owner to know about this. Yes, I can say the answer is yes. A declaration of use or a declaration of non-use is very important to file in a timely manner and in order to maintain the registration. If the applicant does not file the declaration of use or non-use on time or within that period, you cannot renew your trademark registration when the expiration date is close to. So it is important to file the declaration, even those use or non-use with the DIPO in a timely manner. Yeah.
Right. And we should mention as well that filing a declaration of non-use does not have an adverse effect, correct?
Yes, that's correct.
Yeah. So I know that's a concern to some people. They don't want to say they're not using, but it's better to file the declaration of non-use than to file nothing at all, right, Sokmin?
Yes, that's correct.
Okay, and then I believe we have maybe another question about the declaration of use. So let's take that now. So for national registration, it's my understanding that if the 5th year declaration of use is not filed in time, can it be filed at the time of renewal? Please confirm whether this is still the practice.
Yes, in the event that the applicant cannot file the declaration of use or non-use in time during the required periods, they can also file it together with the renewal request. But actually, this is the current practice that we face today, but we cannot assure that whether this practice will be continue indefinitely. So this is recommend that the trademark owner should file a declaration of use or non-use in time during the required period of the 5th year and the 6th year after the registration date or after the renewal date. Yeah.
Okay, and then one last question specific to Cambodia. A certificate of registration is recommended for enforcement cases. Is it mandatory to present the certificate to enforce your trademark rights? What happens if the IR is transferred to another party, so the certificate does not show the current holder in Cambodia?
Yeah, thank you for the question as well. Actually, if you have changed, if you have changed the record with the white ball, you have to submit that information of the change. That means the form of 6 with the DIPO in order to record that with the Cambodian DIP database. So if the record is correctly recorded with the registry, I believe that the trademark owner should obtain the registration certificate when everything is recorded correctly with the DIPO. So that's the issue certificate will be issued with the correct address and the current trademark owner or address, something like that.
So it's better to get everything taken care of and then get the certificate after that. That makes sense.
Yes, that's correct.
Okay. Thank you, Sokmin. Okay, this next question came during Rina's presentation, so I believe it pertains to Indonesia. Can multi-class applications be divided in the event of objection or opposition?
Multi-class cannot be divided in the event of objection or opposition in Indonesia. So that's why we usually suggest to file a single class application.
Okay, all right. And I believe the next question is relating to Thailand. So for an unclear, maybe Laos, I'm not sure. This may be Laos or Thailand, Kun Samboon. For unclear translation, if the local agent submits a more accurate translation to the registry, how long does it take for the registry to review and respond? Are fees payable for this review procedure?
Okay, I think it's probably more pertaining to Thailand because for Laos, they don't really, application can be filed in English anyway, right? So for Thailand, once you file the submissions, like I said, unfortunately for IR right now, the Thai DAP has been pretty swamped, and based on our observation, it's going to take up to 12 months after you file, say, disclaimer amendment before the next, they will be able to have a next turns into looking at your applications.
Okay, thank you.
And on the fees, I would say it's obviously we do charge for that, except in an exceptional cases where we are going to discuss on a case-by-case basis. I mean, if for example, we had a case where we represent our more than 100 year, more than 10 years old clients in figuring out the fact that the Thai DAP has been taking a wrong list of goods to be examined as opposed to the partial list of goods. So obviously, in that kind of cases, we are going to address that on a courtesy basis.
Mm-hmm. Okay, thank you very much. Okay, Rina, I think this may be for you.
Okay.
Due to the pandemic situation, is there any additional specific challenges regarding the alignment of implementation based on the Madrid Protocol and local processes?
So far, we do not see any additional challenges because, for example, for deadline, the deadline is still the same. So maybe because any submission now must be submitted through the online system.
Okay.
So no challenges, no additional challenges.
So everything remains
Yes.
on track. Okay,
Yes.
That's good to know. Okay, back to you, Kun Sombun. For the fast track for Thailand, if we fulfill all requirements, can this be done in 60 minutes or in 6 months?
Okay, good questions. And I saw the following questions asking if this apply to IR or national. So let me combine those. So first of all, fast track, either renewals or fast track examination only applicable to national applications. So unfortunately, it's not going to apply to IR. So that's the first thing. Second things, so we have two paths for fast track. So first of all is fast track renewals. So fast track renewals, it can be done within 60 minutes. That's for renewal. But for trademark prosecutions, it's going to be 6 months. Trademark office promise that they will be able to get back to you within 6 months, as opposed to the normal 12 months right now.
Okay. I apologize. I think I have a little bit of delay right now, but I hope you can hear me. Can everyone hear me? Okay. Another question for Thailand. Yes. Okay, thank you, Kun Sombun. If the distinctive material is less than 60% of the mark, does it mean the entire mark will be rejected? In parentheses, even with the disclaimer over the non-distinctive elements?
Unfortunately, yes, because in the case where there are both non-distinctive and distinctive part in the same mark, the examiner has to decide whether or not the distinctive part outweigh the non-distinctive part. So if so, they are going to ask for disclaimer. But if they believe that the non-distinctive part outweigh the distinctive part, then they are going to reject the whole mark, which obviously subject the brand owners for appeal with the Board of Trademark at the further step.
Mm-hmm. Yeah, okay, great. And another really good question for Indonesia. If the applicant does not respond to a partial refusal, will the application automatically proceed to registration for the approved goods?
Unfortunately, no. If a response is not submitted, the refusal will affect for the non-conflicting goods or services. So a simple response is okay. You can submit a response, okay, I agree. You can delete the conflicted goods, and we agree only to file the non-conflicted goods. So we highly suggest to file a response to secure the non-conflicted goods in the IR.
Okay, very good advice. All right, another question for Thailand. What happens if an IR designating Thailand is refused, citing the very same applicant's prior national registration in Thailand due to different translations or transliterations of the applicant's name. Oh, we see this a lot. How do you overcome this kind of office action?
Okay, good questions, and this suggested that our participants do have a lot of experience in the prosecutions in Thailand. Okay, for IR, let me begin with that. So the person who is going to translate everything, including the applicant name and address, is going to be the DIP, right? The trademark office. So not only that we try to help the clients based on the arguments, but we also try to weigh in our opinions to the DIP every time that we have opportunities. So we talk a lot with the DIP and suggested that this is going to be pretty much annoying to brand owners. And this is one of the practical situation that the DIP is facing. So when, say, if Apple Inc., for example, file applications and designating Thailand, and then when it comes to Thailand, the DIP look into the database as to how best they could put the transliteration of the applicant's name and address, and they found that Apple Inc. has probably using 3 different local firms in Thailand, and each of them has their own transliterations on the applicant's name and address. So usually the DIP would try to use the one that they think is the most appropriate, but obviously it would mean that it's going to be contrary to another 2 set of variations, right? So to make things very, very clear, and I think this is also the situation in China as well. So we need to, if we are sure that everything is perfectly the same, we can file an explanatory letters with our submissions to the trademark office saying that, look, this is the same applicant, and we could testify that by attaching the power attorneys, which was included in the file of the cited mark as well, to show that, look, if you look at the English version, it's the same. And we can also print the WIPO print out as proof as well. So this should usually be okay for waiving these citations. But there are cases also that the transliteration is different, not because of not because only of the transliteration, but it's because the way that the applicant has put in the applicant name could be different. For example, as we all know that in France, there are companies with, sometimes they put the name ABC and then end it with SA, right? Which is the legal status, but some applicant does not. So it become an issue when, for example, in the past, you filed the applications in Thailand on a national basis using SA, but when you file an IR and then designate to Thailand, you do not include SA. And that, in the eyes of the laws and in the eyes of the DIP, I consider 2 different entities. So in that cases, you need to make sure that the name of the entities would be the same. That's the only way that we could do. So which would mean we have to file a record of change of address, change of name in Thailand. Or if you believe that you can do it from WIPO is easier, you can also change the applicant name on the IR with the WIPO to reflect SA. But obviously, in most cases, the clients would choose to amend what they have in Thailand as opposed to change anything at the WIPO.
Okay, so I guess that's a case of not something that seems easy is never quite that easy to resolve. Okay, all right, back to a question we had before that I mistakenly thought was just for Indonesia. Can multi-class applications be divided in the event of objection or opposition? So can we go through our other jurisdictions? Sokmyan, would you like to start with Cambodia?
Yeah, thank you for this one. Regarding to the question, I can say that multi-class application can also be divided if in the event that they have faced with the objection or opposition. So the applicant have to file a request form amendment, which called MM6 with the WIPO. And after that, they have to print out that request form and submit it with the DIPO and informing them about the remove of some class that they want to omit from their application. So I can say that it is possible to devise the class that they don't want to have in their international application.
Okay, so they can delete classes, but can they separate those classes into a different application?
Cannot.
Okay.
Okay. Yeah.
Just to be clear. Okay. Mai Ling, would you like to answer for Vietnam?
Yes, so the same for Vietnam, they may delete some part of the specification, some part of the classes, but they will not be able to devise the application.
Okay. And what about national applications? No divisions there, right?
For national application, they can divide.
They can divide. Okay.
Yes. Yeah.
Okay, so Camille, let's make sure we cover all bases here. For national applications, can you divide in Cambodia?
Actually, for the national application, in the event that the applicant wants to delete the some part of the classification, they can do it so.
Okay,
Yeah.
but no, you cannot keep the filing date and have a new application. So no divisional for in any circumstances. Okay. And Kun Somboon, would you like to go for Laos and Thailand?
Yes, for Laos and Thailand, similar to other jurisdictions, both IR and also national divisional applications are not available. But if you want to delete some of the classification just to waive the citation, that's possible.
Thank you. And Rina, just so we're clear, was your answer before regarding Madrid applications only, or can you divide a national application?
The treatment is the same for national registration and IR.
Wonderful. Thank you all. Very clear. All right. So we have one question. We have 3 minutes left. So I think this will be our final question. As recordal of changes in assignment for IRs we filed directly with WIPO, please advise if any of your speakers have experience in receiving provisional refusals for applications for changes. If not yet, what kind of refusal do you think the Trademark Office may issue? Okay, so we're talking about changes and assignments and whether there are ever refusals about those, and whether, if not, whether there's anything we can think of that might cause a problem. So Sokmin, would you like to start?
Yes, thank you for this question. Actually, I never faced with this problem, but I can say one of my colleagues faced these problems. So in case like the recorder of assignment or recorder of change for the IR have already filed with the DIP with the WIPO. However, the correct data have not recorded with the Cambodian registry. So maybe their local agent or local representative have to follow up with the registry to update that record. And regarding to this, if the IPO haven't received that, we have to remind them again and again to update and to reflect the correct information and add the DIPO database. So this is the problem that I also raised in my presentation. Yeah.
Thank you. Rina, how about in Indonesia?
Student we have not have experience for this kind of assignment, recorder and assignment, but I think so long as the new data, the new detail, the change has not reflected in the DGIP website, the TMO, the DGIP will issue a refusal to your letter mark in case you have a prior mark with the different detail.
Right, makes sense. Okay, Kun Somboon, how about Laos and Thailand?
Okay, either. We haven't seen any provisional refusals on recordal changes, which I believe that is simply because they are given backseat because they don't have a specific deadline to work with, right? But if the question is also asking what kind of refusal that we could think of. So for Thailand, for example, I can imagine that For recordals of change of name or address, the DIP would only accept any official paperwork to support on that. I mean, declaration of change of address or declaration of change of name signed by the applicant on its own will not be sufficient. So that could be one of the potentials that the Thai Trademark Office might be reaching out to the applicant through WIPO, asking for more proof on official records on that. That's the particular situation that I can think of. And please be reminded that recordal of license agreement would have to be filed directly with the Thai Trademark Office, and this is one of the exceptions on the when they're accessing to WIPO Madrid Protocols anyway.
All right, thank you for raising that issue. And Mai Ling, what about Vietnam?
Yes, for Vietnam, same as in Thailand, we have not seen any provisional refusal for recorder of changes. Mostly all the recorder for changes and also recorder for assignment for IR must be filed directly with the WIPO, not via the national route. And of course, like in principle, in theory, the IP Office of Vietnam may review these recorder of changes and issue provisional refusal. However, in reality, we have never seen them. However, recently, the IP Office of Vietnam, they tightened the requirements for recorder of assignment, in which the IP Office of Vietnam requires that all the assignment documents must be signed by the top level of the authority of the applicant. For example, the chairman or the director or the general director. So any other different titles will not be accepted. For example, even the CEO. So
wow, so Elon Musk is going to have to sign any assignment documents?
It's not the chairman. So in that case, they will not recognize the assignment. However, it's in theory. In reality, because due to the lack of human resources at the IR department, so far the Vietnam IP Office do not actively look at all the recorder of assignment for IR. So they practically do not issue any rejections yet. However, in theory, they are entitled to do so.
Okay, very interesting. Well, thank you very much. These questions were great and I think really added to the discussion. I'd like to close now by thanking all of our speakers and our attendees, and I hope you enjoyed the session. You can reach out to Tilike & Gibbons and get in contact with any of us. We would be more than happy to assist you with your Madrid Protocol filings in Thailand, in Cambodia, in Laos, in Indonesia, and Vietnam. So thank you all and have a good lunch.